Good evening, comrades. Hope we are doing perfectly well. It is such a precious moment that we've been blessed to reappear, okay? And in that manner, today we'll proceed with workshop 2, which is to put clear and to your attention. This workshop is narrow, okay? It's a narrow workshop. However, we really need to appreciate things in the wider sense, okay? So, as I've always emphasized, there is a fundamental requirement to extensively read at the back course. So your workshop, if you look at all other workshops, the previous workshops, their coverage have been a little bit wide, unlike your workshops. So what? It's just an indicator that you're supposed to read and appreciate in entirety. Okay, so today, before we get to the entire workshop, I have a few things that I want to really put across to you in regards to, yes, our colleagues, sorry for the short and called for break. However, as I earlier pointed out that your workshop is too narrow, and if I zero down to only the workshop, I'll be a corrupt person, okay? Reason, I have to ensure that okay, we are not after covering the workshop, but as I've told you, the target is always to appreciate. So when you look at your workshop of the second workshop, on the face of it, it only requires you to appreciate what we call enforcement of rights of shareholders and members. Okay? So before even you sit and drill down, I thought it prudent that we first draw our minds to certain types of businesses that are dispatched. We say, we have this type of meeting and this resolution is required. Why? You people didn't take time to sit and understand the gap between dispatch of business and then corporate financing. So your workshop has a missing space. It has a vacuum in between that is supposed to fill. And when I was making the comprehensive recording that will soon be uploaded to our YouTube page, which covers almost everything last Friday, since we were out of time, I reached a time and I didn't break it perfectly well to my satisfaction. So that's why I'm thinking between lines that before we drill to this, because your workshop only requires one case and 2 sections of the law. The entire workshop too, 1 case and 2 sections of the law. So I don't know your coverage, how it is, okay? So put that into consideration. So for us to proceed and appreciate everything that I really want you guys to appreciate, what basically I want us to put our eyes to, dispatch of company business is by way of meetings. So as a result of that, I expected you to have basically appreciated the different types of meetings and what takes place in those meetings. Okay? So In such circumstances, we have basically 3 types of meetings, okay? We have board meetings, we have general meetings, and then court-ordered meetings. Those we covered them. After a meeting, when you propose that are going for a meeting, you should put into consideration that what type of business are we supposed to dispatch at this time, okay? So why? Because you are under an obligation to ensure that you know what you are dealing with, okay? So when you look at that, last time we were able to outline the different types of meetings. So we presume that you've come to the conclusion that you are in need of convening a meeting. But upon you coming to that conclusion, you have to be able also to tell that if we are going for this type of meeting, how should this meeting be called? And we all appreciated that all meetings are called by way of notices, which we looked at and said that notices are of 2 ways. We have an ordinary notice, which is of 21 days. We have what we call a special notice, which of less than 21 days. Then after issuing the notices, calling for that meeting, what takes place after the meeting, okay? We have what we call general principles in regards to meetings. That before a meeting, yes, you've called us, okay? You've called us, you've issued us with a notice, but before the meeting takes place, there are certain things we should put into consideration, of which the first thing is known as quorum. How many people should be present for you to convene a meeting? Okay, when you look at section 141, it is very clear that in a private company, 2 persons present are sufficient to form the quorum. So this implies that even if we attend and 2 people are present, the meeting can commence. We don't care about the absence of the rest. Okay? So if the meeting has commenced, we need a chairperson. The second general principle is known as the chairperson, who chairs that meeting. Okay? At first, I thought the director is the chairperson of the meeting. But however, any member present at the time of convening the meeting, okay, appointed by other members present, is sufficient. If we are 2 and he seconds me to be the chairperson, we are good to go. Okay? And then the secretary will automatically be present. Okay? So if you second me as the chairperson and I start chairing the meeting, then ask yourself, if we've appointed the chairperson, what next? Okay? We shall go for what we call voting. Remember our notice we wrote. When you look at table A, which gives you the contents of a notice, should include the name of the company, the person you're addressing, the type of business, the type of resolution you want. Since we've all come to this meeting knowing that we are going to vote for appointment of a director, we all know. So if the chairperson has chaired the meeting, then we shall go and start voting. So you ask yourself, what are the different types of voting? Okay?
Excuse me, Counsel. Excuse me.
Yes, Councilor Samba, your hand is up.
Good evening, sir. I've not understood. I last understood when we're talking about the different kinds of meetings.
I don't know that these guys are submitting because it must be. I can't share that. Yes, someone is talking. I don't hear anything because of this. Yes. Okay. So I've not had any response to that effect. Okay. So now, when you go to voting, ask yourself, how am I supposed to vote? Okay. We said we basically have two types of voting. We have what we call statutory modes of voting and non-statutory modes of voting. Statutory modes of voting, these are modes that are mentioned in the Companies Act. Okay, they are within the Act. The Act has specified that these are modes of voting. Okay, and the first one is voting by proxies. Is it under section 143? Modes. Okay, they are mentioned under the Act. Okay, they are mentioned under the Act. That's why they are called statutory. Okay, so we've said the first one is voting by proxies. This is why voting by an agent. In case you are absent, you can send someone to vote. So when you're dealing with that, the determinant factor is who amounts to a proxy. On the face of it, you can think that a proxy should be a member, but a proxy can be any person, not necessarily a member of the company. I can appoint my daughter, I can appoint my beautiful wife, I can appoint my loved mom, I can appoint my best friend. But once I appoint you as a proxy, you have full powers like me. Okay? You have full powers like me. If I am entitled to demand a poll, okay? So as a result of that, whenever you appoint a proxy, the proxy will operate exactly like you. If the rights of that proxy have been violated, you can proceed and enforce them. Okay? Okay? If not voting by proxy, another mode of voting is known as voting by a poll. Voting by poll. Okay? This is always looked at in the line of voting according to the number of shares you have. Okay? If you have 10 shares, okay, those are the votes you have. Okay? If you have 1 share, those are the number of votes you have. Okay? A clear example. I'm using this example for academic purposes. Okay? I use this example for academic purposes and for purposes of appreciating the law. Okay? Please mark my words. When we bring a motion in parliament, if you've been following, Okay, what we call the order paper is like the notice calling for a meeting, because the order paper is addressed to all MPs present in the House. The order paper indicates the type of business to be dispatched on that day and the time. Okay, so we come knowing that one of the matters we are going to deal with is amendment of the Constitution. Okay, so because we know we have a group that is in support of it and a group that is not in support of the same. So for us to have, because with the ruling party, we want to defend our position. So what we do, we go for what we call class meetings. Okay, we in support of the government, we shall go to Chankwas. It is a class meeting. Someone who doesn't belong to the national resistance movement, it's a class. Then those who have their own opinion, you'll find some from Najana Nkumbi, those who subscribe to Najana Nkumbi. You'll find those ones in Kamocha. You'll find those ones in Ruvaga, whatever. Those are class. So from those class meetings, we get that one block vote. And you all come to the consensus that whoever came to Chankwan's is supposed to vote for. So it's like we've given all our shares to that person we are entrusting. You get it? So when we come to the floor, we shall all have one solid vote, which is yes. Okay? Why? When we go, we put our trust. A good example is when we are voting for speakership. Okay? They say we are all going to vote for triple A. And it will be triple A. You'll never know. Why? They have decided to come with a strong. So what happens in class meetings? You guys can agree. You give all your shares to Anita. Okay? Then when you come to the meeting, Anita says, let us vote by poll. Remember now, Anita has 80 shares. Those are 80. So you guys, if your group has 20, how can you defeat her? Okay? That's what we call voting by a poll. A poll we vote according to the number of shares. Okay? Then those are what we call statutory modes of voting. Then we have non-statutory. These are not mentioned under the law. Okay? However, what you should note, they are modes of voting. You've seen them, but you have not just put a keen eye, knowing that, yes, this is a type of voting. The first one is voting by show of hands. You've seen this thing even in your classes. Those who say that the answer is correct, put your hands up. You are voting. That's by show of hands. It's not written in anywhere. But since primary, you guys are voting by show of hands. But you can get in orals, they ask you forget it. Then another mode is voting by acclamation. Acclamation, you've seen it in parliament. Those in support of the motion say yes. Those who don't support say no. So acclamation, that voice, yes, no, yes, no. That's what they've been doing in parliament, don't you? Okay, acclamation. Okay. Then if not, it's acclamation. Okay, yes. If not, we have voting machines. Have you guys voting machines? Okay. Okay, so when you look at, we've said that acclamation, it's when you say, those in support say yes. Those who don't support, you say no. Okay, that's how it operates. Then the second one, so we have what we call by voting machines. Are we, guys, are we going to, those who bank with Stanbic basically now? Okay, even if when you go to court, when you are entering court like this near the registry, what happens? There is the machine which has 3 buttons. It has green, yellow, red, and orange. Okay, we have which has very good, good, excellent, poor. Okay, so whenever you get out of court, you have to press a button, how you've been served. Why? At the end of the financial year, those are votes you have voted in favor of the best high court and in favor of the best chief magistrate's court. So they come and collect the votes from those machines. That's what called by voting machine. So when you come, but what they do, clerks, what they do, every time she goes out for a short call, excellent, excellent. Yes, because you need your station to be given marks. Even if when you go to Ginger Road Police Station, it is there at the entrance. When you enter like this, you have to press, how have you been served? So because we don't want congestion, we may say we are voting in for this. Those in favor of this motion, that this should be done, that Rashid should be the director, go and press yellow. Those who don't support Rashid, press red. Okay, so you guys, you come in your free time, you vote and go. You vote and go. So at the end of the day, we bring our computer expert, they extract the data, and we say that Rashid has won. Okay, that's by voting machines.
Because we elected the members of the LDC. The guild.
Then another one. Okay, so as we've said that voting machines, you get a machine with different color buttons. Okay, the color button you press, okay, it tells you that this is for this, this is for this, this is for this. Okay, so as a result of that, you at the end of the day, you get the marks. Then we've said the last mode of voting is known as division lobby. This one we used in primary, vote division lobby. Yeah. Okay, LOBBY. They say those, remember when you're voting for class monitors? A good example is NRM. For us, you know, when we talk about transparency, I'm telling you, may vote for NRM. Okay, why? In their primaries, okay, so when you look at I was talking about the basic example of division lobby can be how we vote in NRM primaries. Okay, why? We tell you, we say it is division lobby. Okay, LOBBY. In that mode of voting, those who have been in NRM primaries, you know what they call division lobby. You stand, we line behind you. You just look back and say, hey, Jesus, no one is behind me. You collapse. Even your wife is behind the neighbor. That's when you realize that people aren't your friends. So division lobby, we say those who support Rashid, this side. Those who support Jeff Vidani, okay? When you look at that, sometimes you may even lose faith in people, okay? So that's why I would credit NRM for transparency, okay? You know at once that Jeff doesn't love me. Simple, okay? Not these things, simanya principle, ya card. Simple. You die once and for all. That's what we call transparency. So division lobby, they divide you into two, red corner and the blue corner. And we get to know who is who. Just look at the blue corner when there are only 6, but everyone is running to the red corner like, hey, I made the wrong choice. Okay, that, okay. So then after you've voted, what comes out of the voting? What comes out of the voting? Then that takes you to resolutions. That was the gist of my introduction. I will say that division lobby basically you say so division lobby will divide people into two, those in support and those who don't support. Yeah, the example is lining up behind your support. Okay, so after you've voted, what comes out of the voting is what we call resolutions. But mark this, in this entire week, you had to sit and appreciate the different types of resolutions, okay? And what type of business requires what resolution, okay? On Thursday, I'm going to bring a paper of last year, but one. That's what we shall do for the IA, okay? What type of business is requiring a particular resolution? They gave your colleagues a question where they had to draft a board resolution, a special resolution, and ordinary resolution on one number. But the challenge is they were not able to tell that if it is voting of directors, we need this resolution. Increase of share capital, we need this resolution. Making a call, we need this. Okay, that's why you had issues on issuance of redeemable preference shares, making a call, and issuing shares at a premium. Why? Some PAs were telling you ordinary resolution. Others were saying special resolution. Others were saying board resolution. I know you had that confusion, but why? You had to that because you couldn't even object, because you didn't appreciate how we get to that point. Okay, so what you should be noting that at all times, okay, what is required of you? Sit and appreciate that, okay, if my facts need increase of share capital, decrease, amendment of memorandum, amendment of articles, what resolution do I need? So now let us zero down to types of resolutions. But I'm going to be a little bit quick. I'm going to give you a resolution. I give you the type of business that requires that resolution. That was the gist of what I wanted before we go to the workshop. Because if I did the workshop, it would have been a disservice, because your workshop is for basically 30 minutes when it is done. Okay, or less even. Okay, so I couldn't go for the workshop. When we had things behind that we have to appreciate, because the week is ending, the term is at the extreme end. Okay, so now types of resolutions. When you look at the Black's-Law Dictionary, defines a resolution to mean a formal expression of an outcome of a meeting. A formal expression of an outcome of a meeting. Okay, a formal expression of an outcome of meeting. Okay, so now let's get to the first one. We have a board meeting. Council Joy, are you having the Companies Act with you? Because I'm going to be giving you different provisions that look at this, look at this, look at this, look at this. Okay? When you see that, just it requires a board resolution. Okay?
Let me have a soft copy. Let me move to my laptop. In a minute, I'll let you know.
Okay, I'll be letting you know. Just stay with the act.
Council.
Okay. Okay, so the first, we said a board resolution. A board resolution is a type of resolution which emanates from a board meeting. Which emanates from a board meeting. So, what does this imply? Okay. This implies that whatever business that is dispatched by directors requires a board resolution. So the question is, what type of business requires a board resolution? Okay. Council Joy, Council anyone with the act? The first one. So whenever you are reading the act and you say the directors may, just know that business requires a board resolution. Whenever you are reading and the law says the directors may, because when you look at, is it Article 78, which says that dispatch of business by directors, the directors may meet from time to time to dispatch business of. So whatever thing that has the directors just know it is a board meeting. Okay, so Council Joy, take us to Article 15, Table A. Article 15, Table A.
Okay, I'm getting there, but someone who is there already can just read this for me, then I'll be set to go for the
Article
next one.
15, Table A.
Article 15, Table A. Have I opened the right one? 15. 15 is on call on shares.
Yes.
The directors. Okay. The directors may from time to time make calls upon the members in respect of it, all or any monies unpaid on their shares, whether on account.
Even if you stop there, Council.
Okay.
Now, the first business, you see, it has the directors may. So what that implies that for you to make a call, it requires a board meeting and approval of directors. So that means that making a call requires a board resolution. Okay. Council, take us to Article 79, Table A as well. Article 79, Table A as well.
Article 79, Table A. The title is borrowing
Yes.
powers.
Uh-huh.
The directors may exercise
Uh-huh.
all the powers of the company to borrow money.
Stop there.
And
Stop there. Another type of business is borrowing. You had that element in your workshop. You had that element in your workshop. But here they gave you, when Rashid, who is the secretary, is the one who has gone to the bank to borrow. When you look at the act, how can a secretary borrow? So that means the directors have to first sit, they pass a resolution to borrow, but not the secretary taking his head to borrow, as it was in your workshop. Okay? But if you couldn't tell, that was a signal that you have to read resolutions. Okay? Which law talks about appointment of secretaries? Okay? Appointment of secretaries. Okay? Okay? Council, go to Article 110, Table A. 110.
Article 110, secretary. The secretary shall be appointed by the directors on such terms and conditions as they may think fit.
Proceed.
A secretary appointed under sub-regulation 1 may be removed by the directors.
Stop there. So now, when you look at that, it has two things. One, appointment and removal of a secretary. Those are two businesses. The first one, you say appointment of a secretary. That's the first business, because the directors, they are the ones that appoint a secretary. So that's one business. Then the second business is removal of a secretary. It also requires a board meeting, which gets where we get a board resolution. So when you are reading your act, you just look at the directors may. Whenever I see the directors may, okay, it's a board resolution, etc. Okay, so let's go to the second type of resolution. It is known as a special resolution. Now, you know, we learn from history. I myself, because I first read the board resolutions that they come from a board meeting, at first I thought that special resolutions come from a special type of meeting, which is extraordinary. Because extraordinary meetings, they come in exceptional circumstances, in an emergency. I said, okay, so now automatically a special resolution should be coming for, yet it's not the case. We have a section that defines a special resolution in the Companies Act. Which section is that? Councillor Gibbs.
Section
Which
1
section in the Companies Act defines a special resolution? Okay. Yes. Yes. Councillor Jeff. Which section? No.
Section 148.
Okay. Amplify. Okay. Okay. Go to section 148, Council. 148.
Section 148, special resolution.
Yes.
A resolution shall be a special resolution when it has been passed by a majority of not less than 3/4 of such members as.
Okay, so when you look at that definition, it is section 148. It says a special resolution should be passed by the majority of a third. Okay, yes, 3/4. When you calculate 3/4, henceforth, it gives you 75%. Fractions, okay? Resolution, which is passed by the majority of 75%, 75% present and entitled to vote. So what does that mean? If we are 10, okay, which number makes 75%? 7. So that means if we are 10, 7 people should be in support of the motion. Okay? 75% of the members present entitled to vote. Okay? Okay? It can come from any meeting. That's the funniest thing with it. Okay? When you guys go to, I think it's insolvency and banking, insolvency, that's where we require a special resolution of a board meeting. Okay? So what you should note that this special resolution doesn't matter which meeting, but what matters the number. The number, not the type of meeting, but the number that has voted for that motion. Okay? Yes. We just the directors, Chiman. We don't mind about numbers. Exactly. Okay. So now, what type of business requires a special resolution? Now, just mark this. Whatever thing that requires a special resolution in the Act says by special resolution. Whatever thing it has by special resolution. And if you don't know what exactly, just know matters that concern the root of the business. Okay? Things that go to the deep of the company, that if this resolution is passed, the company may survive or may not. Okay? That one, it goes to the root of the company. That's why mere voting, we don't call for it. Okay? Now, the very first one, which law requires issuance of shares at a discount? You did it in the workshop. Which section talks about issuance of shares at a discount? Council section 148 defines a special resolution. Okay? Which law talks about issuance of shares at a discount? Yes? Council, take us to section 67. So the first type of business that requires a special resolution is issuing of shares at a discount. Why? To be honest, the company owns shares as its property. We are looking for money. So for you want to sell below the price we want, it is going to affect so we either agree or we disagree. So council, take us to the section. Okay.
Section 67, power to issue shares at a discount. Subject to this section, a company may issue at a discount shares in the company of a class already issued, except that A, the issue of the shares at a discount must be authorized by a resolution passed in a general meeting of the company and must be sanctioned by the courts.
Okay, why? It is the strictness. Okay, then which law talks about decrease of share capital? Decrease of share capital, not increase, but decrease. If you want to decrease the share capital. Okay. Decrease of share capital. Yes.
On issuing shares at a discount, does that section 67
decrease of share capital?
Councillor Rashid.
It is 76.
Increase.
76.
Mhm.
76.
Decrease of share capital.
Council, it is 76.
Council, take us to section 76.
Section 76, reduction of share capital.
Yes.
Special resolution for reduction of share capital.
Then if you stop
Subsection
there,
1.
don't add on. You see, it is very clear. Million. So if we want to decrease it to 5 million, how are we going to earn? How are we benefiting from it? It is going to affect our dividends at the end of the day. So we should have agreed as the entire company. Okay? It is section 76. Okay? Section 76, decrease of share capital. Okay? It also requires a special resolution. Okay? Then which law talks up, council, take us again to section 40. So another requirement is change of name. Okay, change. Okay, another type of business that requires special resolution, change of name.
Can I read?
Change of name.
Section 40, change of name. A company may by special resolution and with the approval of the registrar signified in writing.
Even if you stop there,
its name.
You see, I told you, whenever it requires special resolution, the act will speak. The act will always speak. Okay? Section 40. Okay? Council, then another type of business that requires special resolution, go to section 10. It is known as
which section, Council?
Alteration
I lost you.
Of memorandum.
I lost you there.
Section
which
10.
section?
Go to section 10.
Section what?
10.
Okay. Section 10. Section 10, mode in which and extent to which objects of the company may be altered.
Yes.
A company that has included in its memorandum, its objects may, by special resolution, alter its memorandum with respect to the objects of the company so far as may be required to enable it to, one, carry on its business.
See? It is clear that if you want to amend, now let me tell you, they told you that you guys wanted, the company had to borrow money. No, so? It had to borrow how much? How much? They wanted to borrow from the bank. It was 2 billion. 2 billion. And so, look at its share capital. What was the share capital of that company? Okay. So that means all of these resolutions, you had to draft them indirectly. They didn't tell you, okay, that you have to think of this. They showed you one that the company wants to borrow. You know, Article 79 says directors. So you needed a board resolution. Then after the board resolution, The very article tells you you can't borrow beyond the share capital. So you had to first come here. You go for what we call increase of share capital. Okay. Then after changing of share capital, it had to be reflected in the memorandum. Then you had to come back and also amend the memorandum because we are going to present it in the bank. So then indirectly, the workshop was telling you to put emphasis on resolutions, but it was salient. That's why they told you the numerous documents. But the way you approach the workshop, don't know. Okay, that's the back course. Okay, let's proceed. Okay, so Council, take us to section. Now, let me give you these sections, are very simple. When you are all sections that deal with re-registration, okay? All sections that deal with re-registration of a company, they require special resolution. Should we give a test suit? Re-registration. Let's assume you are a private company. You want to turn into a public company. You need a special resolution. You are a single member. You want to turn into a limited liability company. You are a limited liability company. You want to turn into a public. All such things. So when you come to these sections and they are following each other, Council, let's make a test suit. Go to section 24. All will say that everything that deals with re-registration, change of format of the business of the company shall require a special resolution. You have a private company turning into a public, special resolution. Public company into a private, special resolution. Limited by shares to turn into limited by guarantee, special resolution. We said let's make a test suit.
Section 24, re-registration of.
Take us to section 24.
Section 24, re-registration of private company as a public company.
Okay.
Subject to this section, a private company other than a company not having a share capital may be re-registered as a public company if a special resolution that it should be so registered is passed.
Okay.
I continue.
That's section 23. When you look at all those, okay, they require special resolution. Okay. So when you are reading, so what basically is required of us to, you see, facts are funny. The way they said facts, they'll never tell you that we want you to talk about a special resolution. You've seen, I've just shown you your workshop. Everything was there. It required a resolution. But how many PAs pointed that out? Okay, why? They wanted you to take your time and read. I told you this workshop is wide, but they made it narrow because they know you guys are tired. But you remember in the introduction on Saturday, Council members said, make sure you appreciate the entire week. This is our area of orals. Now they know that they are going to ask within this area. So I said, no, we shouldn't spoon feed them. So they will leave it open. So let's go to another type of resolution. So in your free time, when you are reading this act, when the section that requires a special resolution, to always tell you. Always tell you. Okay. It was special. Okay. Now let's go. Seven. No, it requires 75 of the members entitled to vote. Okay. So what happens? Some members are not entitled to vote. Are you aware of that?
Rashid,
People who are
excuse me,
given
Council.
shares at a premium, they don't vote. They don't vote. You know the powers they have. One person can vote on, because remember, you buying a share at 50K when it is of 80,000, you should be given preferential treatment. So they vote, but their voting powers are limited because they know. Okay.
Council Rashid, I have a question. Council,
Yes.
Council, I have a question. I'm seeking for clarity.
Yes.
How would you tell, can you hear me?
Yes, I
Council,
can
there
hear
are
you.
some provisions of the law that yes, there are some provisions of the law that are not clear. For example, when you look at Article 15, Article 35, they just tell you a resolution. So how do you tell the type of the resolution they want to use? Is it a board resolution or ordinary resolution?
Where if the type of business has the word directors, okay, even if it doesn't tell you, it is a board resolution. But where the section doesn't have the word directors and it just tells you resolution, it requires an ordinary resolution. So that means the business that they are dispatching is not so much that important. You get it?
Yes, Council. I get
Okay.
it.
So Council
Because
is
today I
asking
was
here,
discussing those things, and when I told
do you
the PA
increase
asked
stockholder?
me what is the
Okay.
source of
It
your
is the-
information.
Now, what happens in such circumstances, Council Charity? You pass two resolutions at the same time. You increase and alter at the same time. Okay? Because whatever you increase should be reflected in the memorandum. Okay? She was talking about when you want to borrow and the money you are borrowing is above the share capital. So you pass two resolutions at the same time. Yes, you can. Okay, so we go on. Ordinary resolution. So an ordinary resolution is a type of resolution which requires a mere majority of 51. A mere majority of 51, provided we are not equal. Majority of 51%. Okay? A mere majority. Okay? Because it is not so that paramount in life. Yes. Okay.
So, Council, does it mean that it's the kind of resolution that is created in a meeting ordered by court, class meeting,
okay,
and extraordinary meeting?
Oh, what you should note that this ordinary resolution and a special resolution, they come from any meeting, provided these ones we look at numbers only. Okay, numbers only. That's the gist. Okay, so should we make a test suit, or I just mentioned for you guys? Okay, the first one is appointment of directors. Okay. To be honest, you've read directors. The act is salient. It said directors shall be appointed at the annual general meeting. Hey, simple as that. So that means it requires an ordinary resolution. Then another one, appointment of auditors. It is very clear. The law is salient. Okay, very salient. How to appoint the auditor. Okay. Auditors. Let's go to the section, appointment of auditors. Section 167. It just says that auditors shall be appointed. Okay. But it doesn't specify how. Okay. Then directors are appointed under which article? Okay, no, no, subsequent. Okay, 194. Okay. Okay, subsequent directors. Okay. So you see, when you read those sections, they are just salient. So whenever you are reading the act and it is salient on the type of resolution, it is sufficient. Just know that it is an ordinary. Simple as that. Okay. 190. Council section what? 194. Appointment of directors. It's 190. 94. Okay. So you see, these things can be done in a simplest way, but your workshop will always not tell you. So it requires that exceptional touch when you are really committed. Okay, but everything is possible. So me, when I read your workshop, I realized it had, because it's done. It's not coming back. Whatever you had in your books and whatever you have, that's what you managed to collect. Okay. I realized that these facts had notices, meetings, and resolutions, but they skipped them from the learning outcomes. So it was supposed to be you, because I always tell you, LBC hits in personam. Don't think that your farm leader, your group members will do what will make you pass. Okay? It is you to do what will make you pass. And may I believe you can. Okay? Yes. So now, after us appreciating that, okay, now let us zero down to workshop 2. Okay? So now, an insight in workshop 2. Okay? Yeah. Okay? So, an insight in workshop 2. Okay? Don't forget, the reason why I'm using an insight, our YouTube page is known as, okay, the Legal Insight. Okay? Yes? To subscribe? No. Okay? Okay? So, an insight. Before we read the law, I want to explain to you just mere appreciating what we are going to deal with. When you look at your workshop 2, its elements rotate around rights of shareholders and members, and how those rights can be violated and enforced. Okay, so when you look at your facts, the first thing you have to appreciate, who is a shareholder? The first thing in workshop 2, who is a shareholder? Then after appreciating who is a shareholder, you were under an obligation to proceed and ask yourself, okay, what rights do these shareholders enjoy? So you had to open that Companies Act right by right. And some of them were listed in your workshop, but you couldn't see. Okay? Some of them were listed in your workshop, but you couldn't see. Okay? Just mark that. Okay? They are listed. Then after looking at these rights, then ask yourself, if they are violated, what remedies are available? That's when you go for what we call enforcement. So ask yourself, the enforcement is in 2 categories. Okay? We have enforcement by court and enforcement by the registrar of companies. So your facts are calling for which mode? Okay. So when you look at the enforcement, it has the locus case. This enforcement is basically known as the rule in force versus haboto, what we call the minority rule. Okay, that's sometimes you can find where it is called force versus haboto. If not, it can be called the minority rule. If not that, it can be called, it has a third name. It has a third name. Who is deliberating us? Council Afla. You want to share?
It's the rule that is called in the management rule.
Council Mas. It has a third name. That is Takwadi's rule. Okay? It has a third name. It is known as, it has a third name. If it is not force versus haboto, okay, it is called the minority rule. If not, the third name. Others may call it an alternative remedy for winding up. Another name, there's a lot of names. Because you might get in orals, they tell you cancel. Educate us on force versus haboto. Hey, we didn't talk about bottles. Okay? It is HAB. Okay? If not force versus haboto, they can tell you cancel. What do you understand by the minority rule? Okay? Then others say cancel. What do you understand by the alternative remedy of winding up? Was I here? Eh? Okay. But it has another name, the fourth name. Okay.
Proper playing
force versus haboto. If not that, it can be called the force versus haboto, the minority rule, then alternative remedy for winding up. Then the first name is known as a derivative action. A derivative action. Derivative, D-I-R-A-T-I-V-E, derivative action. Okay, that is the fourth name. So, but all those things, They mean the same thing. So it's upon you to read the different cases. When you read the case of Olive Chigongo versus Musa Courts, it is the court referred to is as a derivative action. When you read Force versus Saboto, that's where it emanated from. That's what it's called Force versus. When you read section 247, it is very clear. Alternative remedy for winding up. So it is a case-to-case basis where you are depending on your mode of appreciating the law. We are going there. I'm just giving the general. So for you to appreciate your workshop, you have to read the different rights. With whatever right is violated, you have to prove that the business of a company is being conducted in a manner prejudicial to your interest or other persons. You inclusive, okay? But the reason why this system is not so much that easy to appreciate, the general rule is a company upon incorporation has capacity to sue and to be. So if you are saying that the matters of a company are being conducted in a manner prejudicial to its interest, so you think a company doesn't understand? You get it? You get the technique? So that is the exception to the corporate personality. Okay? Where a member of a company can sue on behalf of a company. Okay? Are we together? We've said the general rule is once a company is incorporated, okay, we proceed and ensure, okay, that the company sues in its own name. But we have circumstances where the company cannot sue, okay? Where you see a director conducting business in a manner that is not promoting the interest of the company. Because remember, the directors are the hearts of the company. That's why the Baganda sent him Matokolachi. So the director will not be able to sue. So now that's where you, the member, you will come to save the company and sue. Why? If you leave these directors to conduct the business in that line, the company is going to be liquidated. An example, you may not have heard about the UTL saga. Okay, by the time those things happened, I was very, very, but I just read the genesis and how things ended. When you look at UTL, it was the richest telecom company in East Africa. Okay, so this company, every mast, every car, every bike, every office was registered in its own names. It is the only telecom company that wasn't renting. You know that MTN, Airtel, those guys were renting from UTL, everything. Okay? So when the directors came, they saw that there was a lot of money. So these guys used to sit and they pass resolutions in their favor without consulting the stakeholders, because the stakeholders were the government of Uganda. So they had to seek permission from some things from the government. So they could seek, they pass a resolution, they increase their salary. And they made sure they are the first priority in payment. Okay? Now, after that, whenever they see that the motor vehicle looks a bit old, they say they pass a resolution to dispose of all the vehicles. They sell themselves the vehicles. So after some time, the company wasn't operating well when we don't get profits. So that's when the president said, no, there is a problem here. I need to act. So when they called them, the president realized that the company was being conducted in a manner prejudicial to the interest of the stakeholders. So instead of, remember, this is a public company. Okay, so instead of filing to the registrar of companies, that complaint was filed to the floor of parliament and the directors were called. That's where Honorable Anite was appointed to revive Uganda Telecom. And she told Ugandans that at least every Uganda, you people buy the SIM card at 500 shillings. But Ugandans are big-headed. No one bought. So she sat and thought, if we leave this company like this, it is going to be liquidated. So what alternative remedy do we have? So they had to enforce. That's why they made it mandatory. Each and every government official has Uganda Telecom. All office lines are every police officer, all OCs and the DPCs, they use Uganda Telecom. MPs, their official lines are Uganda Telecom. And the army. And then the internet provider of all government entities is Uganda Telecom. Okay? But they subscribe from UTL, but that contract is for UTL. So after that, these directors were sacked. Why? They complained that the manner in which the company is being conducted is prejudicial to our interest. So instead of leaving the company to be liquidated, we have to find other means. Why? But when we talk about it, it can be changed. That's why in your workshop, this guy doesn't want to leave the company. He still wants to be in the company, but he wants to cause a meeting so that he talks about it, so that the registrar makes an order that something should be reversed. Okay? Are we together? So basically, that's what we are going to be dealing with. So and now I want us to read now the law. Then after, we read the facts and we call it a day, inshallah. Okay, so now, first things first, who's a shareholder? Can so first take us and read for us the learning outcomes? Okay. And read the learning outcomes of workshop 2. Okay.
Learning outcomes for workshop 2. By the end of this workshop, you should be able to, 1, describe the rights.
Workshop 2. Someone with the workshop here so that I can read. Okay. So the learning outcomes are, by the end of this workshop, you should be able, 1, describe the rights of shareholders in a company. That's why I told you, you can't proceed and tell me that you're going to look at the rights of shareholders when you don't understand who is a shareholder. Then that means you have a problem. Okay, we proceed. Then 2, enforcement of shareholders' rights in a company. Okay, how do you enforce your rights if they have been infringed on? Okay, then to present and prosecute and defend a petition before the registrar of company and or high court. So what does this mean? Regardless of the fact that your workshop may not be dealing with either the registrar, it can't be dealing with the 2. Okay, so that means the enforcement can be done at the registrar's office or the high. So you should be able to appreciate the 2 circumstances, that if, because they may give you the IA when it is before the registrar of the high court, and for you to draft a document which is going to the registrar of companies. At that point, you already have a 0 peacefully. Okay, so you should be able to tell, okay, that is it going before the registrar of companies or before the High Court of Uganda. Okay, then to address ethical issues. Those are what we commonly call ethical dilemmas. So now, let us get to the law. We don't have any section in the Companies Act that defines the shareholder, okay? But we have case law. When you read the case of Matthew Rukikaire versus Incafex, court defined a shareholder, Matthew Rukikaire versus Incafex. Court defined a shareholder to mean a person who has been allotted shares. Who has been allotted shares. But if you look at this, it doesn't matter whether you've paid up or you've not, provided you are allotted shares, it is sufficient for you to be called a shareholder. Okay? Who has been allotted shares. Okay? Once you have shares, whether you've paid them up or not, okay, you are a shareholder. So at that very point, ask yourself, at what point does someone cease to be a shareholder? You can't cease to be a shareholder if the required procedure is not followed. Okay? So when you look at Article 15, Table A, okay, it gives the directors powers to make a call on unpaid up shares. Okay? After a call has been made and this person has not exercised the right to redeem, okay? You've not paid, okay? When a call has been made, then the company will proceed and carry on what we call forfeiture, okay? Once we forfeit, you cease to be a shareholder, okay? And again, when you read the same case of Incafex, court held that all members are shareholders, but not all shareholders are. Yes. All shareholders are not members, but all members are shareholders. Okay, this is the same thing. It says all members are shareholders, but not all shareholders are members. A member is in the register. A shareholder, just you have shares. Okay? But all members are shareholders. This is the same thing. I've come from the end and from the beginning. Shareholders, they just have shares. You can be a shareholder when you're not in the company register. Not so? Yes. But when you're not a member. Okay? So now, after appreciating that, ask yourself, what are the rights of these shareholders? Okay? Some of the rights, you discussed them in workshop 1, but you were not sure. The first one, a right to vote. A right to vote. So what does that mean? That dispatch of company business, all stakeholders should vote. All shareholders, members, directors, if they are available, they should vote. So nothing should be conducted without approval of the entire team. So if it is done, it becomes a violation. Okay? Then another right, a right to receive notices calling for meetings. Once I am a member and I don't receive a notice, that meeting is null and void. Okay? You already had them in workshop, with your workshop 1. but just emphasis and how to add things to make sense. Okay. Then a right to appoint proxies. Section 143. A director should be a member of a company. If he's a member, also enjoys the same rights. Councillor Derek, your hand is up.
Yes, Council. Good evening, colleagues. My argument was actually on the previous part of the case of Olive Chigongo and Matthew, because the latter statement you made of all shareholders, all members are shareholders, but not all shareholders are members, was actually in Olive Chigongo case. And then in the Matthew Chekere, it was actually a different thing, because the trial judge in his judgment was looking at it as allotment. When you allotted shares and you entered on the members list, you become a member, which was again disagreed with in the judgment of Olive Chigongo, and of which on the other side, for a person to be a member, they had to be subscribers to the memats in the start. And remember, memats are published. So when you publish, that is when you become a member. And the fact that Olive was was a subscriber to the memats before, it made her a member at the same time a shareholder. That was what was held. Yes.
Now, Council, the distinctive feature that basically is there, those guys all agree that everyone has a right to be in the register of members. But the contention is who should enter that shareholder in a register. Is it the duty of the company or the duty of the shareholder? Okay, that's why they have that divergent point, because these guys are saying that if section 119 says the company should maintain the register of members, it is its mandate. Okay, but if another section says that the shareholders and members, they have the right to inspect the register anytime, so that means inspect and see if your name is not there, proceed and find means on how you should. That's why the law even gave them the right to bring that action of ratification of the register of members. Okay. We proceed, Council. Okay. Then another right. Another right. A right to dividend. You have to share the profits we get. A right to receive dividends. A right to receive dividends. Then another right, a right to own shares until forfeiture. A right to own shares until forfeiture. Then another right, a right to transfer shares. A right to transfer shares. So you can transfer to any person as per the memorandum and articles of association. Okay. Then another right, they have a right to bring a derivative action as per section 247. The right to bring a derivative action. Okay, derivative action. Another one, they have a right to inspect the register of members. Then another right, they have a right to inspect the register of beneficial owners. That is an amendment. A right to inspect register of beneficial owners. That's an amendment. Register of beneficial owners. Then, yes, then they have a right.
Council.
They have a right to petition court for liquidation stroke winding up. To petition court for liquidation stroke winding up. Then they have a right to access books of accounting. etc, etc. Okay, so now you have to appreciate all of these rights. Okay, maybe another right, they have a right to be treated equally. They have a right to be treated equally. So now, when you were you to read and appreciate the workshop, you have to first read these rights. Why? Your facts, they have rights that were violated. So you can't tell me that you wanted to read the facts before you understand the rights. There was a problem. So that means either you're going to leave out some facts when you've not appreciated them, because you've limited yourself to only particular. Are we together? So now, after looking at all those rights, ask yourself, how do we enforce rights of members? If you want to enforce that right, what options are available? That takes us to what we call enforcement of rights of shareholders. Okay? Workshop is done. No. Okay.
Council, the last bit, what did you say?
Proceed. Okay.
No,
enforcement of rights of shareholders. Now, what should we start with? Council, take us to section 247. Okay.
Section 247, alternative remedy to winding up in case of oppression. A member of a company who complains that the affairs of the company are being conducted in a manner oppressive to some part of the members, including himself or herself, or in a case falling within section 178 subsection 5, may make a complaint to the registrar by petition for an order under this section.
Stop there, Council. So when you are reading that section, we have things we want. One, jurisdictions and mode. Okay? We want jurisdictions in enforcement, okay? Mode of application and factors considered. They are within the same section. Jurisdictions, okay? Then factors to be considered, and then the mode of application within the same section. Okay. Jurisdictions, factors, and mode. Okay. So what should we start with? Let's start with mode. Okay. Mode of enforcement. Mode of enforcement. Okay, we've said jurisdictions, mode, and factors. Okay. So when you read section 247, it gives you the mode, okay, and says it is by way of petition. So the mode is a petition. (247). So it is by way of a petition. Yes. Okay. So we've answered the first one, mode. Okay. Then the second one is jurisdictions. So the jurisdiction we've said are divided into two. We have High Court or Registrar of Companies. So you should be able to appreciate under what circumstances do I go to the Registrar of Companies, and under what circumstances do I go to the High Court. Okay. So now, Council, let's go back. Okay. Let's go back.
247. Council, section 247.
Yes.
Alternative remedy to winding up in case of operation. A member of a company who complains that the affairs of the company are being conducted in a manner oppressive to some part of the members, including himself or herself, or in case of failing within section 178, subsection 5, may make a complaint to the registrar by petition for an order under this section.
Okay, so it says a registrar, okay? The registrar for an order under this section. So the question is, who is a registrar? Okay, section 247. Who is a registrar? Yes, yes. So we'll say the first one, the jurisdiction is registrar of companies, registrar. But remember, High Court has a registrar and the companies, they have also. So you want to know which registrar are they referring to here? Okay, so you come to the definition section. Does the definition section define a registrar? Okay. Council, take us to the definition section. Go to section 2.
Section 2.
Yes.
Registrar means the registrar of companies or an assistant registrar or other officer performing the duty of registration of companies under this act.
So you see, so what that means, that here we are dealing with a registrar of companies. So under section 247 subsection 1, you file before the registrar of companies.
Section
247 subsection 1, you file before the registrar of companies. Yes, we shall see. Okay, so when you look at this section, it says a member. So for you to bring a petition, okay, to bring a petition to the registrar, you should be a member of a company. So when you are not a member, you don't go to the registrar of companies. That's why in Olive Chigongo, because she filed this petition to High Court Commercial Division. Why? Her name had been scrapped off the register of members, so she could not go to the registrar. That's why court had to sit down and they determine whether she's a member or not. Okay. Okay, we proceed. So now we have where, okay, we refer to the High Court. So let's go to filing to the High Court. Now we want to, so we have to read the facts between. You say, these facts are for High Court or to the Register of Companies before we take any action. Council, take us to section 248 now. Okay, 248.
Section 248.
Yes.
Section 248, protection of members against prejudicial conduct.
Yes.
A member of a company may apply to the court by petition for an order under this part on the ground that the company affairs are being or have been conducted in a manner which is unfair, prejudicial to the interests of its members generally, or of some part of its members, including at least himself or herself, or that an actual or proposed act or omission of the company, including an act or omission on its behalf, is or would be so prejudicial.
So you see the distinction between these two sections. Huh? This one has the word, the interest of members generally, okay, where a certain portion of members have not benefited from a particular decision. But when you read 247, it says a member of a company who complains that the affairs of the company are being conducted in a manner oppressive to some part of members, including him or her. You get it? 248, it has that wide range of people who have been affected in the first place. Okay? Both they have the word a member. Okay? But when you look at this, when you look at the case of Olive Chigongo, their plaint, it had brought under section 248 because they went to court. Okay? However, council's determination was she was not a member. She couldn't qualify. Okay? But after, in rejoinder, Council submitted using subsection 2. Council read section 248, subsection 2.
Two 248, subsection 2. The provision of this part apply to a person who is not a member of a company,
Stop there.
but to whom shares.
Okay. So stop there. What does that mean? When you look at this, even someone who is not a member of a company can proceed under 248. So 248 has what we call wider applicability. So in council's argument was saying that Olive Chigongo is not a member, so she doesn't qualify to bring this petition. Council replied she was falling under subsection 2. You get it? Because she was no longer a member, her name was scrapped off the register. And this right is only available to members because the section says a member. So what does that mean? It's only a member to exercise this right. And Olive Chigongo didn't qualify to be a member because she was not in the company register. That's why court had to determine. Okay. Subsection 1, it has what we call general applicability, that a biggest number of members should have been affected, because it says that on by petition for an order under this, on ground that the company's affairs have been conducted in a manner which is unfairly prejudicial to the interest of its members generally, when the effect of such actions affects almost everyone in the company. When guys are salient like this, you take it on, that if I die, I die. Let me save this people. Okay. Yes. Okay. So, for you decide, have you ever been home? You want to beg something, but since Brenda is the last born, they will give her. So Brenda can tell mommy, should we eat some yellow bananas? You know how she comes. Mommy, why? If you front this person, things will be. But all of you have been in the sitting room looking at the apples and the yellow bananas. You want to, but because of the fear that, as you know, your mom Hajat, when you get the yellow banana, she doesn't talk. She says, then you get notice Zao, that African eye. But this, if we front the last born, the African eye doesn't work. So here you are all in a basin being oppressed, but you can't speak. So that one person comes out and says, we are all generally affected by your actions. So when you look at this, okay, in your facts, this guy, it was only one person being affected, not so? So it couldn't amount to a general matter. So, because it was him as a person. Okay, sorry for preempting the facts. So you would proceed under section 247, subsection 1, to the registry. Okay, but that's why they said stroke. They knew you can interpret it as the registrar or interpret it as the high. But what I know, counsel for the week will go for the high court, because they can't proceed before the registrar of companies. They'll take them to the high court. They proceed before the registrar of high court. So you should read between lines. Simple as that. Yes. For the mood, or for workshop too. For the mood or for the workshop? Workshop 2, workshop 3. Are you sure? We are going to read the facts. You will see. Okay. Okay, so okay, so we go on. So now, who has ever read the case of First versus Hamilton? Okay, I want you guys to read that case. Okay, First versus Haboto. Okay, the case is First versus Haboto. Wait, my page is misbehaving. Okay, and these global markets as well. So now, the first is FOSS, Haboto is HARBOTTL. When you read the case of First versus Haboto, they refer to this as the proper plaintiff. Why? Because of what I told you, that in all company matters, it should be the company who is the plaintiff. But this is the exception to that. It's that here, the company can't speak, the company can't breathe, because the directors are sitting on this company. It can't come out. So you come out and you save the company. That's why it's called the proper plaintiff role. Okay? So get time and read that case. When you read that case, it goes further to define what amounts to a manner prejudicial. Because that is the ground upon which you bring your action. That, okay? The manner prejudicial, that what amounts to prejudicial conduct, it was defined in that case. Okay? When you read it, says that it was said that in the case the shareholders cannot bring an action for loss suffered by the company. Okay, you should show that the company is suffering a loss, but it is oppressing the shareholders. They can't speak. Okay, now you, the shareholder, you comes out, you sue on behalf of the oppressed. Yes. Because you have to include their names.
Do you also have pass a resolution?
No.
So pardon, please, on that issue. Thank you.
Yes. 247. Okay. So you have to read between lines. So now, comrades, allow us to go to our facts. Okay.
Just before you go to the facts, I wanted to confirm what 1482 is about. You said it's people that are not members at the time of the
Okay, now what that means,
There's you wanting to go to the High Court, but you are just one person. But you go and be heard before the registrar.
So if you are only one affected, you go to the registrar of companies. If a substantial people are affected, you can go to the registrar.
So that's where an individual outside, not even
Aha, yes. In 248, even an individual outside the company can come and sue. Yes, just prove that the services of the company are affecting you, including the members. Okay.
So, Council Rashid.
Yes.
Senior Council, I have a question.
That's why whenever those construction companies, yes, Council had a question?
Senior counsel.
Yes.
So does it mean that the only remedy you're seeking for is winding up under section 247?
It
or you
is
can
called,
even have other
it is
plans?
called alternative remedy. You are foregoing, okay? You are foregoing winding up of a company that let the company survive. But the facts surrounding, okay, can cause winding up, but you forego to wind up this company.
Thank you.
That's what operation is a case-to-case basis. If any of the rights you mentioned above is violated, you can go to the registrar. Yes. That's by petition. All company matters are by petition. Okay? Simple as that. Yes. So let's read our facts. We add them up. We see if what we've read really makes sense. Matthew Inca, Fakes, Olive Chigongo, Malgola Farmers. I kindly read that for basically what I would advise you to read. I want you to read the case of Renachievable Chemist Uganda Limited. It is a must read. I want you to read Renachievable Chemist. Yes. Uganda Limited, 1977 HCB. This case is going to be hard for you to get on URI. I know you've searched for it. They shared it. Read it. It has that rule. It was the first case in Uganda where force versus saboteur was applied. Okay? Renachievable Chemist. Okay? Read it. Then you read the case of Olive Chigongo versus Mosa Courts Apartment Limited. Then Force versus Haboto. If you can read those cases in their entirety, you are good to go. You're not supposed to read each and everything, okay? For yes, and maybe what you should appreciate is that the reason why they gave you Frederick Izawe versus Orient Bank, okay? When you look at our facts, this guy was not around, not so? How did they execute and sign on his behalf? The director was in China, not so? Powers off. So he had to have given them powers. It didn't apply. These are company matters. Transfer of his shares, that was his property. Did he consent? Again, fraud comes in. Frederick Reserve. Okay? So let's read our facts now. You can also read the case of Cliff Masagas. Okay? Cliff Masagas. I think it's not on a reading list. Okay, but it is, let me give you the citation. It is Cliff Masagas versus Afriland First Bank. It interprets section 248. Cliff Masagas versus Afriland First Bank. It's not on your reading list. Yes, Afriland, yes. It is it's AFRI, then land. First Bank. Read the case of Cliff Masagas versus Afriland First Bank. It interprets section 248. So let's read our facts. I will lead you. Okay. Now, we know how we read our facts, but the biggest challenge that your workshop has articles, okay? Has articles. So we are not going to be able to go through the articles of association. It's approaching 10. But you have to read them before, because some of the things might have been dealt with in the memorandum. Okay? And you say that the rights were violated when the guys signed the memorandum and they agreed. Okay? Okay. Sayings that consider the memorandum and articles of association in workshop 1 as amended here under. So what does that mean? Before you proceed to do anything, the right thing to do is to first read the memorandum. Before you start reading the facts, the rest of the facts, you have to first read the memorandum. But you find a legend who read the facts before reading the memorandum. Okay? That is the first mistake you guys did. You had to first read the memorandum. Why? The memorandum of association gives how the company is governed. So whatever rights you may think that were violated, what if this guy signed the memorandum and agreed upon them? Okay? So you come here shouting for us, violation of rights, violation of rights. And at the end of the day, you come to realize that there were no rights violated. Okay? Prudence of counsel. So now ask yourself, did you guys exercise the prudence of counsel? Did you read the memo? Counsel Master, did you read the memo? Are you sure?
Who?
Haja, did you read the memorandum?
Yes.
Okay, so make sure you read this, but let me give you the interpretation of the rest. It says that on the 15th of December 2023, Young made a telegraphic transfer of an equivalent of Uganda shillings 200 million shillings from his account in Exim Bank to the company account in Stanbic Bank as at Parliamentary Avenue. Okay, he made a transfer from his account. Okay, what was that money for? What was that money for? That's the first thing to ask yourself. What was that money for? Okay. When the said money hit the company account, Nkoyo Rashid convinced Carson Muranga that since they were hard up and the Christmas festive season was approaching, they would each share a 50 million out of the money received from Young to enable them entertain their respective families and even cater for their New Year celebrations in Dubai. Why do you have this? When money is on the company's account, you first come and look at the memorandum. Okay? Who has the power? Who has the power to deal with the money? That's the first thing. Okay? Who has the power to deal with the money? Who are the signatories? Okay? So you come and look at your memo. It is not dealing with how to deal with money, but when you look at these facts, Young remained with the balance of some money, not so. What if he was paying for his shares? And what if he was paying for his shares? Remember, it was from his personal account and the money dropped on. Now ask yourself, okay, this money to be withdrawn Was it for purposes of the company or personal gain? Then you go back to 47, that the affairs of the company are being conducted in a manner prejudicial. Does that favor the company in any way? The director is going to Dubai for the holiday. Does it uplift the image of the company? So you underline that is a manner which is prejudicial to the interest of the company. And besides that, when you go to, is it section 178 or 79, duties of directors, directors have a duty to conduct business of a company in a manner that promotes its success. Does that promote the success of a company? Okay, you put as that is a violation. Okay, we go on. So the duo anticipated that it would take long for Young to return to Uganda in view of the recent Ebola crisis that has scared away many foreigners. They anticipated, you underline the word anticipated. Did they have proof? Proceed. So after them anticipating, what did they do? What did they do? On the 20th of December 2022, Rashid and Carson met and decided that since Young was away and had not fully paid for all his shares, they could allocate them to their longtime friend, Senoga John. Okay, what are the rights of Young? He has a right to own shares. What is the procedure for taking back shares? Allotment. Okay, he was allotted, he's a shareholder. At what point does someone cease to be a shareholder? Article 15, 17, 16, and 18. Procedure of forfeiture. Was it followed? That means it is prejudicial to the interest of Young. You see? His right to own property was. Then we proceed. Okay, they allocated them to their long friend Senoga, who was ready to immediately pay them that. They signed a resolution and filed a return of allotment showing 400 shareholders, including Senoga, who was allocated 250 shareholders that originally belonged to Young. So you come here to our memo, okay? This memorandum has what we call transfer of shares, okay? Transfer of shares. So you come and read here, okay? Did they follow the right procedure? Okay, they don't have making a call. Now, look at proceedings of directors. Is Young a director? Young is a director, not so? Look at Article 6, it says, the directors may meet together through virtual or physical meetings for dispatch of business, adjourn and otherwise regulate the meetings as they think fit. How did they pass the meeting? They sat two without including Young. And the memo is clear. Couldn't Young attend by virtue? Did they consider the memorandum violation? Okay. And then go to 7. Questions arising at a meeting shall be decided by a majority of votes. Okay. Who was the biggest shareholder? You get it? So was there a violation or not? Okay. Then come here. Okay, go to 10, which says that there shall be a 7 days written notice of either a virtual or physical meeting of directors. The company secretary shall serve. Come back here. They anticipated that Young will not return to Uganda soon. Did they give Young a notice? He has a right to a notice. We'll go back to our question. Okay. Then it says that on 10th of Jan, Young returned to Uganda. On cross-checking the records of the company, Young was shocked to discover that he had purportedly attended a meeting of 20th December 2020 via Zoom. Look at, underline the word purportedly. Purportedly, what does that mean? Was he aware of the meeting? That means he didn't receive the 7 days notice. Under our rights, we said he has a right to receive notices. So that is a violation. It is confirmed. Okay, we proceed. Young has also discovered that the company had obtained a loan of Uganda shillings, that out of which they paid the remaining balance of the purchase of the company land in Mukono. On completion of the transaction, the land was registered in the joint names of Rashid Nkoyoyo and Mabel Kateraro, the wife of Kason Muranga. Okay. The borrowing of money. Who has the power to borrow? Directors. How many directors? There are 3. How did they come to that conclusion without the other director? Then there's a problem, a violation. That means he had to attend the board. Did he attend? Right violated. Okay. Then the directors executed a debenture over a company assets as security for the above loan. There are no official records of all the above transactions of the company. This is what we call a manner prejudicial to the interest of the company. That you guys are doing things for your own benefit, but not for the benefit of the company. Okay. We proceed. Young has made endless efforts to cause meetings of both the directors and the shareholders, but his efforts have been frustrated by Rashid and Carson, who have been dodging and giving him flimsy excuse to avoid attending. What does that mean? He has taken all reasonable steps, but nothing has come out. Young has approached you as a prominent lawyer in Mukono to advise him on his rights pursuant to the Companies Act as amended. So do you need to advise him anymore? We are done. That's how simple the workshop was. So you couldn't tell me that you wanted to go for enforcement when you don't know the rights. Corporate and commercial is the simplest course unit at LDC. But why it becomes difficult, your mode of addressing, it's the simplest. But the challenge is its volume scares you. Secondly, it has a lot of laws and you people are allergic to reading laws. Okay, you want simple things of criminal, okay, which have the same law that you keep on citing from year to year. Okay, so when you look at this, to be honest, how was the workshop difficult? Okay, but your mode of approaching the workshop. So when you are dealing with corporate and commercial, I always tell you, be open-minded, ready to learn. In corporate, we don't be at the receiving end. Don't wait for the farm leader to compile the work. They'll compile wrong work. You have the law. Read the law yourselves. I always tell you. You guys, the challenge, you first read the facts. You want to apply the facts. Now, if you read these facts, unless you already know, okay, that this paragraph, it is this right. This paragraph, it is this right, okay? That will be simple. Now I can read the workshop before I even read the law, because I already read the law. But we left undergrad when we are as green as a newborn baby. I'm telling you, whatever we did at undergrad, we passed by the God's grace. So LDC presumes that we were brilliant students at the undergrad. We appreciated the law. So by the time you get to LDC, they presume you know the law. But when you get to, it's when you realize that at undergrad you did nothing. So the reason why you see LDC as a dead end, you are doing two things at the same time. You read the law and the facts. Yet at LDC, you have to read the facts only. LDC, they teach people who already know the law. Okay? Not to those who are going to read the law at LDC. So whenever you get a workshop, first ask yourself, this workshop is within what range? Read those laws and appreciate them. Come and read the facts. You see, when we read the laws very fast, when you come to the facts, it doesn't take us 10 minutes when we are done with interpreting the facts. But the reason why you misinterpret questions, you still have a poor touch on reading the law. So the question is, how are we going to improve on reading these laws and understanding them? Should we just get classes on how to read the law? That's another question. Will time be available? So why do you allow yourself to misappreciate the law? Okay. So that one's 1 week. It can be 1 week, it can be done. Even the week is due, like 4 days. Okay, so but what is required of you? Sit and read the law, and then after reading the law, make sure you take your time. These facts, they are very simple. That's why these PS laugh at you. Okay, because you rush to the facts. Okay, it's like entering a girl's heart without money. You can't. You'll be stuck in jam. And someone comes from nowhere. See? So, hey, how has Gibbs made it to Brenda's heart? Okay. So you'll be sent, you'll be there saying, struggling to enter Brenda's heart. Why? It's the same thing. You're struggling to understand LDC when you've not appreciated the law. So sit, read the law first. Don't panic. Okay? You see, imagine now you're panicking to copy notes. Workshop 2, maximum 6 pages. Maximum. And when you've written a lot of Rugambo, but you hear panicking, the work you can even write in 3 hours. But take time and read. These guys have given you simple workshops to make you read, but they're going to make your life hard in orals. That's the reason why they're giving you simple things. Now, you guys, you saw workshops of the previous years. You read the workshop when you don't even understand it. Okay? But your workshop, I read the entire workshop, your entire workshop in 30 minutes. And I know that this requires this requires this. But last year, I could read even 2 days. Okay? So these guys, when they make things simple for you, it's danger. It's dangerous. Okay? So take your time, sit and appreciate the law. Don't panic. Okay? So unless otherwise we have questions, I welcome them for like 5 minutes. and we call it off. Council Jacqueline, your hand is up.
Thank you, Council. I'm inquiring about the defenses, the possible defenses that the company could have.
Yes?
The possible defenses.
Now, just know all the defenses, okay, are in the memorandum. That's why they gave you the memorandum. First, ascertain whether what they did is in the memorandum. Why? All of them signed the memorandum. So the defense they have is consent. Simple as that. Okay. Any other question, Council? Yes, Council David.
Thank you, Council. Council, I have two issues. One is a concern, then the other one is a question.
Yes.
Let me begin with the question. I don't think we have covered the issues.
It's okay.
The second is a concern. Since we have advanced ourselves to the level of uploading our stuff on what is this thing called?
YouTube.
YouTube, right, thank you. I'm urging ourselves that we behave more decently. Because when you listen to the previous upload, it has so many issues. We were yawning. I mean, there was a lot of stuff in the background, which is so much unpalatable. If this one will be loaded, I'm sure, uploaded, I think it was so smart. So smart. Because in the background, there was no yawning, there was no making funny things. Since we are going beyond the borders of LDC, we are going beyond the borders of Kampala, Uganda, Kenya. I mean, we are worldwide. I think let's give respect to what you have initiated, and it is appreciated because many people are going to subscribe. And I feel it will build so much onto your own respect and to our own respect. That is my concern, Council.
Okay, thank you, Council. One, let me first respond to the question, ethical considerations. The reason why we rarely deal with ethical considerations, the questions are clear, advocate. So that means all ethical issues emanate from the Advocates Act. Okay, that's the first thing you should appreciate. So the ethical considerations, they rarely change. You should have instructions, executing them timely, diligently advise your client. Those are ethical considerations, bribery, corruption. Remember, it's going to the registrar. People think at the registrar's office, you can proceed and bribe anyhow you want. Those are ethical considerations. Then our concern, I really appreciate this team for the tremendous work and appreciation. However, as you know, at times when we are starting, we have what we call the transitional process. We learn by experience. We have been open to numerous comments. Yes, the content wasn't bad, but those different things that's had to be dealt with. That's why today, this one is a bit different, okay? Then we also have a comprehensive one of workshop one, the other Friday class, which has from company up to the end. It is also done for editing. We're supposed to forward the same, okay? And this one is also going to be edited. It is going to be uploaded on our YouTube page very soon, inshallah. So as a result of that, I still appreciate you people. You are such a strong team who are so instrumental in making me a better person. I can't take you for granted. Your advice, corrections, comments are welcomed. We are a family. And where you see any of us going astray, you are under an obligation to correct him or her. So council, your concern is welcomed, and I really appreciate the same. More modifications are going to be made. If you've realized that today the volume is a little bit different, okay? The tone is a little bit different, and that's one of the modifications we are trying to make. More modifications are going to come up, okay? Thank you, Council. Then Council Judith, your hand is up.
Council, thank you so much. But my question is in regards to the matters that go before the registrar. Isn't there a limitation? For example, in our facts, we have issues of fraud. Isn't there any limitation to such matters?
Now, the biggest challenge is you should basically appreciate, okay, what we call a matter prejudicial. So anything that is done contrary is prejudicial. If it is not putting the interest of the company at the forefront, it is prejudicial to the interest of the company. Whether it was acquired fraudulently, whatsoever the case may be, okay, it is prejudicial to the company. So it is a case-to-case basis, Senior Counsel.
Thank you so much, Counsel.
Okay. And then lastly, comrades, I pray that you continue subscribing to our channel. I appreciate whoever who has subscribed. May the good Lord keep blessing the work of your hands. Kindly proceed and subscribe. Spread the gospel, because the Bible says that whoever shall get shy of me, the eyes of man, okay, I'll also